Excellent. So, trustee school, almost everything that you need to know about being the trustee of a special needs trust, because certainly, things are going to be very specific to your family. If you're the beneficiary, specific to you, or if you're the trustee, specific to the person that you're providing for. But a lot of the administrative items are going to be common no matter what kind of trust you're administering and no matter what the details are of your specific beneficiary. So, what is our goal today? Our goal today is to understand the responsibilities of a trustee, to discuss trust administration, including the use of care managers to ensure quality of life. Review the basics of government benefits. A lot of individuals who are beneficiaries of special needs trusts are on government benefits. So understanding those government benefits and how those government benefits can change over the lifetime of the beneficiary is very important to understand how to administer the trust. And that is to the last point, really understanding the relationship between government benefits and trust administration. Can the trust pay for a vacation? Is that going to impact someone's eligibility for Medicaid or SSI? So where do we begin? What we frequently hear is, my mom set up this trust for my sibling. She named me as the successor trustee, and now she has passed away. Maybe I wasn't really that involved in the trust administration while mom was living, but now I am. I'm the successor trustee. What do I do? Where do I start? Well, we start with reading the trust agreement. What exactly does the trust tell you to do as the trustee? Confirm the current government benefits. Is it Medicaid? Is it Medicare? Is it both? Is it SSI? Is it Social Security Disability? Is it Social Security Retirement? What type of government benefits is the beneficiary on, if any? And if you need assistance, you can hire professional assistance. That might be an attorney, a CPA, or someone else to be able to help you with the investments of the trust and the overall trust administration. But let's start with what is a trust? I mean, what is actually the trust agreement that we're talking about? So a trust is a legal agreement where a settlor, the creator of the trust, is transferring ownership of assets to a trustee, the manager of the trust, to hold those assets for the benefit of one or more beneficiaries, the people who get to benefit from the trust administration. The trust can be revocable, meaning it can be changed, or it can be irrevocable, meaning it generally cannot be changed. When the last living settlor, the last person who established the trust, passes away, a revocable trust automatically becomes irrevocable. Now, a special needs trust is a specific kind of trust, and it refers to a trust for the benefit of a person with a disability. Now, it can be a third-party trust, meaning it's funded with assets that were never owned or available to the beneficiary. Or it can be a self-settled first-party trust, meaning it's funded with the beneficiary's own assets. So lots of different terms here: revocable, irrevocable, third party, self-settled. But the idea is that it's a document that's identifying who created it, who's going to manage it, for what purpose, and why are we setting up this trust? What is the goal at the end of the day? Now, exempt special needs trust. I oftentimes have families who come into me who don't have estate plans, or maybe they have a simple will and they realize that they have a child or a grandchild with special needs, and maybe not having estate plans or having a simple will is perhaps not the best plan. And so they say, why do I need a special needs trust? Well, a properly drafted special needs trust is not included when we are calculating the beneficiary's assets, or income for government benefit eligibility. So if someone applies for Medicaid or someone applies for SSI, we disclose the trust, but if it's properly written, the trust is not counted as an asset and it's not counted as income. And Riley's going to go into some of those eligibility rules to really understand the connection there. And as I mentioned before, there's two broad types of special needs trust, and they're primarily distinguished by who owned the money or the asset right before it went into the trust. Is it a third party trust, meaning that that asset or that cash or that investment account was owned by someone other than that beneficiary? Or is that money already in the beneficiary's hand, which means it's a self-settled special needs trust? And there's a really important reason why we make that distinction. And we're going to talk about that in an upcoming slide. But whether it's a third-party trust or a self-settled trust, no matter who is putting the money into the trust, the administration of the trust is generally the same. Now, third-party discretionary trusts. Again, these are funded with assets that never belong to the beneficiary with a disability. So let me, illustrate this in a um, using an example we oftentimes see. Let's say grandma names her grandson as the beneficiary of her life insurance, and she names her grandson by name. And so when grandma passes away, that $20,000 life insurance benefit belongs to that grandson. If the family comes to me and says, oh, grandson is on Medicaid and SSI. We know he cannot have more than $2,000 in countable resources, but he's going to have $20,000 from grandma. We know that's going to be a problem. What do we do? Well, I would say, okay, we're going to have to create a self-settled special needs trust, or that's one of the options I would give to the family. And they'd say, no, no, this money came from grandma. Why wouldn't we do a third party trust? This is grandma's money. Well, it may have come from grandma, and grandma may have been the one that paid the premiums her entire life, and grandma may have been the one that, was the owner of the insurance policy. But at grandma's passing, the proceeds from that insurance belongs to grandson as the beneficiary. As a result, you can't put that life insurance into the third party trust after grandma has passed. It is now grandson's money, and we're looking at a self-settled trust. So the third party discretionary trust is very important because that is pre-planning. You're setting it up. If you're the person who's planning for someone else, you're setting it up during your lifetime and you are funding it during your lifetime, or you're naming that trust as the beneficiary during your lifetime. So it never goes into the hands of the person with the disability, because once it's in that individual's hands, then the planning options are different. Most of the family trusts created by our firm include a beneficiary with a disability, and this is a type of third-party discretionary trust. So if you're watching and you're one of our clients, and you open up your estate plans and you look at the trust that was created and it says the Jones Family Trust, you may go, oh my gosh, how did our attorneys mess up? Why doesn't this say Special Needs Trust? Well, that's when you need to dig a little bit further, because chances are within that document, there is a section that is in fact a special needs trust. It's just not labeled special needs trust at the very top, because the label at the top does not matter. It's kind of like what your mom always said. It's what's on the inside that counts, right? Um, Now, a third-party discretionary trust can be available as a resource for the beneficiary if the trustee can spend the money on medical care, comfort, maintenance, health, welfare, general well-being. This is language taken directly from Ohio law that says that if these words are included in the trust, they are red flags, and Medicaid and the Social Security Administration can count the trust as an available resource, and it can cause the beneficiary to be ineligible for Medicaid and SSI. So part of the practice that Riley and Matthew and I have is we sometimes are looking at trusts that other attorneys have drafted, and we are reviewing it and we're giving an opinion on whether or not we think it would be an exempt trust, meaning Medicaid or Social Security would not count it as a resource. There's also something called a sole benefit trust. We like to mention this here because we know sometimes there are parents or grandparents who are thinking about their own long-term care planning. And this is a really neat feature that is available in Ohio. It is a third-party trust, meaning it's funded with assets that didn't belong to the beneficiary. It is exempt, meaning it's not counted for Medicaid or SSI. But the person who's creating it, they themselves may need Medicaid for long-term care. We see this when a parent or a grandparent has a child or a grandchild with a disability, and that parent or grandparent needs long-term care either in their home or in a nursing home. So they need to apply for Medicaid themselves. You may have heard about the 5-year look back or the 60-year, or excuse me, 60-month look back or the transfer penalty or waiting periods. None of that applies to the sole benefit trust because under Ohio law, um, uh, there are certain transfers that can be made and there's no penalty. And a sole benefit trust is one of those transfers. It's not counted as an asset for the beneficiary of the trust, and the person who put the money in the trust, they're not penalized either. So they're eligible for Medicaid as well. It's really a win-win planning tool for both the establisher of the trust and the beneficiary. So that's not our primary purpose in talking today, but we just wanted to kind of let you know that this is a great planning tool for individuals who have someone in their life with a disability. Not everyone is aware of it, but if you have a diagnosis, and you want to preserve some of those assets for the loved one that you've been taking care of, um, for their whole life, and you're nervous that you're going to end up spending that money on your own cost of care, please know that there are some planning opportunities out there to preserve money for them that won't jeopardize their eligibility and also won't jeopardize your own for long-term care. So let's talk about the self-settled special needs trust. This is the situation, using the example I had earlier, where grandma has named grandson as the beneficiary of her life insurance. He is receiving $20,000 and we can't undo that beneficiary designation because grandma has already passed. So one of the options is creating a self-settled special needs trust. So there is a Medicaid payback trust, and then there's also the pooled Medicaid payback trust. So the Medicaid payback trust, it can only be established by a parent, grandparent, guardian court, or a competent adult beneficiary. Same with the pooled. The beneficiary has to be a person with a disability. One important distinction is that with the Medicaid payback trust, the beneficiary has to be under the age of 65 when it's funded. With the pooled Medicaid payback trust, Ohio does not have an age limit. So the person can be over the age of 65 when the trust is funded. With either trust, Medicaid does ask to be repaid at the beneficiary's passing, which is why it's called a Medicaid payback trust. It's kind of an idea of, well, we'll allow you to stay eligible for Medicaid, we'll allow you to stay eligible for SSI and other means-tested benefits, but in exchange, when the beneficiary passes away, the state of Ohio is going to have a claim against that trust and they want to be repaid. Now, that highlights the importance of pre-planning because if grandma had maybe done some pre-planning, maybe had done the third party special needs trust or had used one of the other tools that were available and didn't name grandson as an individual beneficiary, perhaps we could have avoided needing to use the Medicaid Payback Trust. The other item I want to highlight is that with the pooled Medicaid Payback Trust, there is the option to allow the money to stay in the trust at the beneficiary's passing. And the nonprofits that run the pooled trust, they can share how they use that money, but a lot of times they use it for charitable purposes like making grants for individuals with disabilities or to provide services for other nonprofits that serve individuals with disabilities. Now, with the Medicaid Payback Trust, the trustee is chosen by the person who's creating the trust. And so they work with their attorney to, identify, is that going to be a family member? Perhaps is that going to be a bank? Who is it? Maybe the attorney? Who is going to be the trustee? Whereas with the pooled Medicaid Payback Trust, the trustee is pre-selected by the nonprofit trust advisor, and every single beneficiary has the same trustee. Typically, the trustee is a what we call corporate fiduciary or professional trustee, meaning that it is a bank. For example, there is a nonprofit in Middleburg Heights called Community Fund Ohio. They work with Huntington Bank currently, and there is a pooled trust in the Dayton area called the Disability Foundation, and they work with KeyBank. So two banks that we're very familiar with in Northeast Ohio. Now, with the Medicaid Payback Trust that an attorney would draft, the settlor can elect to include a trust protector, can add some other people to the mix to give more, give a feeling of more control or, to kind of have that liaison between the beneficiary and the trustee, especially if it's a corporate trustee. Maybe you want a family member to be able to advocate on behalf of the beneficiary. With the pooled Medicaid Payback Trust, they require a designated advocate. Sometimes they use different terms, but the idea is they do require someone to serve as a contact. And the really neat thing about the pooled trust is that the beneficiary can serve as their own designated advocate. So it allows someone who is competent, but perhaps has a disability to advocate for themselves. So that is a really nice feature. And I will tell you at our firm, we oftentimes include the power to create a pooled trust in our trust agreements or in our powers of attorney because you don't know what the future holds. And sometimes working with one of the pooled trusts makes sense from a financial standpoint. And also sometimes family members prefer not to serve as trustee. Maybe it's overwhelming, or maybe there just are not a lot of family members to choose from. And so having that pooled trust is kind of a safety net or a default option is very helpful. And we include that in a lot of our drafting. So, when should a self-settled special needs trust be considered? Why would we do that? I frequently have people come into the office, and when they're choosing, or when they think they're choosing between a third party special needs trust that has no Medicaid payback when the beneficiary passes away, and they're choosing a self-settled special needs trust that does have the Medicaid payback, they're like, oh, well, I want the third party one because I don't want, the Medicaid payback. Well, it's not actually a choice. The question is, where did the money come from? Who owns the money or who has access to the money right before the beneficiary has passed away? So as a result, when would a self-settled special needs trust be considered? Well, when the individual with the disability has accumulated enough assets and needs to retain eligibility for means tested benefits, that, the money is already in their hands. When there's an inheritance, I don't mean that someone is doing pre-planning. I mean the person has already passed, and so the individual with the disability is receiving the inheritance. When there's a lack of planning or outdated or incorrect planning, someone thinks that they did the right planning, but unfortunately, perhaps something was overlooked. Improperly drafted trusts that can't be corrected, we oftentimes can correct them. There's a lot of things that are available, in 2026 that weren't available when I started practicing law, which I'm now into my, 20 plus years, but we can do things now that, we couldn't do before some changes in the law that were available to our clients. But occasionally there are things that are beyond correction, even with getting the court involved. So that is why sometimes we have to put that money into a self-settled special needs trust. When there's a lump sum from Social Security or other sources, what we say like a back pay, personal injury or other litigation proceeds, perhaps child support. Perhaps the parents have gotten divorced and child support has been ordered. We do get involved in those matters, and we do encourage that parents get us involved early so that we can be a part of those discussions as opposed to trying to address things after it's already been decided, because there are some ways that we can maximize the benefits that a child is eligible for and also maximize the planning that the parents might be doing for that child. And then also when other tools, such as ABLE accounts or spending down that money, just are not viable options. And now I am going to turn it over to my colleague Riley so she can discuss trustee responsibilities.
Hey, so we have, I think we should start with what is a trustee? The trustee is either an individual or an entity. Lots of banks and financial institutions have a trust department within them that can act as trustee over a trust, but that is, again, the individual or entity that has control over the trust property. The trust is a legally complicated relationship, and you, as trustee, might be administering the trust for many, many years. So it's really important to understand your responsibilities as a trustee, and talk about your fiduciary obligations. So, a fiduciary is a person that manages the money or the property for the beneficiary, and they are held to the highest standards of care and loyalty. So the trustee is the fiduciary that takes on these responsibilities. We'll go into more of the fiduciary duties, but some of them can be clerical, record keeping, taxes, um, a little on the maybe simpler side, but others can just require good judgment. Your job as trustee is to make disbursements to the beneficiary while considering lots of other factors, government benefits, what those government benefits might already be providing for the beneficiary. So, really, you just need to have some good judgment. And it's really, really important that the trustee know that they are not alone. The trustee can hire other professionals. So, for example, advocacy, a care coordinator. If the trustee is very well versed in financial matters, but maybe not as well versed in healthcare matters, you as trustee can hire other professionals to help you with administering healthcare decisions, ensuring that the beneficiary is seeing a doctor regularly, receiving the correct care and correct medications. And obviously, the same the other way. If you're versed in healthcare matters, you can hire an accountant, or another professional that is very well versed in tax filings for trusts. And typically, we advise our clients that they should have some help somewhere. This is a big responsibility that individuals are taking on. So it just is so important that everyone know they are not alone in administering a trust. Amanda, I cannot advance the slides, so if you can move on. Thank you. So these are our three big fiduciary duties. This is a very word heavy slide, but these are the really important things that the trustees should know. There is a default rule of no self-dealing with the trustee or immediate family members. So any individual acting as a trustee should not be borrowing money for themselves. They should not be investing in their own business. They should not commingle assets. But you also need to consider that immediate family members that maybe are not the beneficiary of this special needs trust, whether it's a first party or third party trust, they should not be borrowing from the trust. So you as trustee aren't giving out loans to anyone. The most important thing with this trust is that you provide money to the beneficiary and it's for their benefit. Um, Unauthorized self-dealing is immediately presumed to be fraudulent. So avoid it in all ways that you can. Delegation, this is what I was talking about a little bit before. So if you are a sole trustee, so there's just one individual acting as trustee, you can delegate duties to other individuals. You can hire a care coordinator, caregivers to help take care of the beneficiary, investment companies, you can hire tax professionals, but also if there are co-trustees, you can delegate duties among one another. Lots of families that we work with will list two individuals to act as trustee together to help maybe balance out some of the powers and the duties that they will be taking on. They might consider even nominating two individuals because they have different skill sets. So there are times where we've had clients that have a child that is very well financially versed, a financial planner, and a child that's in healthcare. So they might act as co-trustees, and one handles financial matters, the other handles healthcare matters. If someone's not available to do that, we can delegate those duties among one another or among any other individuals. A trustee can also delegate all or most of their duties by entering into an agency agreement with a bank or other financial institution's trust department. The final big fiduciary duty that we cover is investment. So when the creators of the trust pass away, there might be limited funds and the beneficiary might be young and have a long life ahead of them. So we want to ensure that as long as that beneficiary is alive, they have money that they can access for any of the things that they might need. So often the trustee will do investing to, again, ensure that the money continues to grow during the beneficiary's lifetime so that they will always be taken care of. So our two big investment rules is the Ohio Prudent Investor Rule. So that says that the fiduciary should manage the assets as a prudent investor would. So you should be focusing on the total portfolio and objectives that are reasonably suited to the trust. You should be doing periodic management, diversification, and minimize unnecessary risk. You should also, as managing any investments, exercise reasonable care, skill, and caution. We also look at the modern portfolio theory. So that just maximizes the return that the trust would receive based on a specific level of risk. And again, we do a lot of diversification. So diversification is required unless the trust is better served by not diversifying, or if the trust agreement allows for non-diversification. But how I think of diversification is don't put all your eggs in one basket. You should invest across various assets, classes of assets, and industries. Thank you. You also, as trustee, have reporting requirements. So the trustee can report and should report to beneficiaries or surrogates. It is possible that the trustee would also report to the probate court or benefit agencies. So to the beneficiaries or a surrogate of the beneficiary, the trustee should be providing an annual accounting of trust activities. Um, this also provides a lot of protection to trustees. Once an accounting is provided to beneficiaries, they have 2 years under Ohio law to file a claim for breach of fiduciary duty. So it's something that you as trustees should be doing. But it also provides protection to you to say that somebody can't come in 3 or 4 years down the road after you've provided an accounting and say, oh, I found something and I think there's a breach of fiduciary duty. You might also have to report to the probate court. There are times where an individual is under guardianship and they are receiving benefits from possibly an inheritance or a settlement. If that's the case, we have to ask the probate court for that individual that is under guardianship to create a trust if the funds are so large and there's no way to spend them down or put them in another account like the ABLE account that Amanda was previously talking about. So if we have a court supervised special needs trust, then we provide either accountings every year, and in Cuyahoga County, we provide accountings every 2 years. We have to ask for authority to use the funds that are held in the court supervised trusts before we spend as well. And then there are times we have to provide reports to benefit agencies. So that might happen at an annual redetermination period or when it is requested by that benefit agency, like Social Security or Medicaid. As trustee, you are also facing some special challenges, especially when dealing with a special needs trust. So often the beneficiary of the special needs trust has diminished capacity or is in need of certain services like Medicaid, Social Security, and those will affect how you administer the trust moving forward. Now, trust administrations can be very simple. You know, it can just be, I am approving certain expenses for the beneficiary, but they can also be incredibly complicated. The trust may own property that you need to manage, and you might need to hire caregivers, certain agencies, other assistants. So the with the special needs trust, the first party, so the self-settled special needs trust that Amanda was talking about, you will also have to consider the status of the state as a beneficiary. So the state of Ohio's Medicaid department gets a super creditor status. Once the beneficiary of the special needs trust passes away, we or you as trustee would report that the beneficiary has passed away, and the state of Ohio's Medicaid department reports back what the Medicaid claim might be. So Medicaid keeps a running list of what they have expended for the beneficiary during their lifetime. And any funds left in a first party special needs trust would be repaid first to the state of Ohio. Any funds left over after the state is repaid would be distributed according to the beneficiaries listed in the trust document, whether that, again, if they are individuals listed or if the beneficiary is the estate of that individual. You also, again, I talked about this a little bit, but consider court involvement. So sometimes, again, if the court retains jurisdiction, the trustee needs to provide filings to the court. You file an inventory that lets the court know these are the assets in the trust. You ask for authority to spend the funds. You provide accountings and some additional reports to the court. You should also consider the needs of the beneficiary and their income. Very often, public benefits are not enough to cover the expenses for beneficiaries, so they might need to dip into the trust assets more often. However, there are lots of times where we see clients that are getting all of their care needs met with the benefits that they're receiving from Social Security and Medicaid, so they might dip into the trust assets less often than others. So it's just a consideration of what the beneficiary needs. You should really ensure that you are involved in the beneficiary's life, you understand their needs, and you're doing periodic check-ins with them. You should also consider the benefits that they're receiving. We don't want, if an individual is receiving SSI, generally speaking, SSI is meant to cover room and board expenses. So if we are using trust funds to cover all of those room and board expenses, we might be reducing our SSI benefit. So the trustee should consider and weigh and balance what the beneficiary is receiving and what disbursements are being made from the trust. Something else I was previously mentioning was caretakers. As trustee, you might be responsible for selecting caretakers that either come to the private home, are in a group home setting, ensuring that the beneficiary of this trust is taken care of. If they need caregivers, you should make sure that the caregivers are providing adequate care, that basic needs are being met for the beneficiary from those individuals. You might also need to secure services and additional equipment. You might need to also redirect the caretakers and family and the beneficiary. So being a trustee can be very complicated with family dynamics. And at the end of the day, you have to remember as trustee, your job is to do what is in the best interest of the beneficiary. Sometimes the beneficiary might call you as trustee and say, I need $5,000. But if the individual is on Medicaid and SSI, so those needs-based government benefits, we don't want to provide $5,000 to that individual because it will affect those benefits. You should also review, if there is one available, a letter of intent. Often when parents or other individuals are establishing a trust for their special needs child, they will create a letter of intent. This states what the family believed the trust would be good, or how the trust would be used in the future for the beneficiary. Now, the trustee is not held to this because we have to give discretion to the trustee in making distributions, but it can be used as a guideline to understand how a family wanted their disabled child or beneficiary to be taken care of. If you could move on, Amanda. The basic disbursement rules. So I just want to preface this by saying these rules are presumptive. They are not absolutes. There are times where it makes sense. While we're saying maybe you shouldn't do these things, there are times it makes sense that you would do these things. It is a balancing act. But if a trust beneficiary is receiving needs-based benefits like Medicaid and Social Security, as general rules, we should be making payments to these providers of goods and services. So, for example, if a beneficiary says, I need a new couch, the beneficiary can go with you as trustee to Live-In Furniture and pick out whatever couch they want. But you, as trustee, will write out a check or pay with a credit card, debit card, whatever means of payment, you're going to pay Live-In Furniture directly. We're not going to give the beneficiary $3,000 to buy the couch. Again, as a general rule, we should not be giving cash directly to the beneficiary, and we do not pay for shelter expenses because, again, SSI is meant to pay for those expenses. Vehicles typically should not be titled in the trust. They should instead be titled to an individual. And if that vehicle, like the one shown on this slide, is used for the benefit of a disabled beneficiary, the trust can hold a lien on the vehicle. But generally speaking, we do not want the trust to own the vehicle because if there is some type of accident, liability falls onto the trust. Then if you as trustee or another family member is the primary caregiver of a disabled individual, you might want to consider purchasing life insurance on that person's life because that can be used to help, once that individual is gone, pay for additional caregivers or needs of the beneficiary. If at any time the trustee wants to purchase a prepaid funeral arrangement for an individual that's receiving benefits, ensure that that prepaid funeral plan is irrevocable, because if that is irrevocable, it is not countable for Medicaid and Social Security purposes. Like I was saying earlier, um, the trustee might be managing something more complicated like a residence. Parents might intend to have the beneficiary remain in their home for as long as possible. So often families, when the creators, so parents of the trust pass away, the residence transfers to the trust and is managed by the trustee. So and then the trustee will manage the property for the benefit of the beneficiary. The trustee should consider the cost of maintaining the property. So bills, insurance, maintenance. You might also consider the size of the property. Once, mom and dad might be living in a 5-bedroom house. When they pass away, if there is one disabled individual living there, that property might be too big. So to cut some of the costs, you could consider having roommates move into the home with similar situations, other individuals that might have similar disability or care needs. So roommates can move in. You have to think about, if we have disabled individuals living in these properties, do we need caregivers? Full-time, part-time? Who will be doing that? Who will we be hiring or paying? What family member will step in to do those care, to meet the care needs of the individual that remained in the home? And then now I'm going to pass it back to Amanda.
Thank you, Riley. I appreciate that. So I hope everyone brought their pencils and calculators because now we're going to jump right into doing tax preparation, right? We all love this part. No, I'm kidding. We're not going to do that. I'm not going to make any of us fill out the 1040 or 1041. But my goal in the next couple slides is to boil down very dense information into hopefully like bite-sized pieces. Now, of course, like anything that we're talking about today, there are going to be some specific nuances that might be particular to your family. But this is, in general, what people can expect in terms of special needs trust and tax reporting. So when a trust earns income, meaning, you invest the money or you get a 1099 because it earns interest because it's in a savings account or a CD or an investment account, that income is taxable. It might not be working, it might not be, the trust is not getting a W-2 from an employer, but it may be earning income off of its investments. And so you need to think of the trust as a separate taxable entity and who is paying taxes on that and who is required to file the tax return. So let's start with the third party special needs trust. So remember, this is the trust that's not funded with the beneficiary's assets. Perhaps this is a parent who has established a family trust and they've already opened up a bank account or an investment account. If the trust is empty, there's no assets in it, then no tax reporting is needed. So I don't want to alarm you. If you have worked with your attorney and you've created a third party trust, and the third party trust is going to be funded, but only when you have passed away. I don't want you to think that you've been missing anything in the years since you created the trust because you haven't done a trust tax return. Remember, if the trust is not earning income, whether that's interest or dividends or whatever kind of investment income the trust might be earning, then it doesn't need to prepare a tax return. You can always talk with your attorney or with your tax preparer to get specific information for you, but that's a general rule of thumb. So our third party special needs trust, it's not funded with the beneficiary's assets, but let's say there are assets in it and it is earning income. If the trust is revocable, it's reported on the person who set it up, the settlor, on their 1040. So if I create a special needs trust to be funded with my money for the benefit of my child with special needs, and I go ahead and open up an investment account, if I'm in a situation where I can put money in it during my lifetime and that money is earning income and I'm getting a tax document at the beginning of well, about now, right? We got a tax document probably in late January or early February, and I go, okay, what do I do with this tax document? Well, if it's a revocable third-party trust, I'm reporting it on my 1040. But if the trust is irrevocable because I have passed away, remember, and a revocable trust becomes irrevocable when the settlor passes away, or it becomes irrevocable because it was irrevocable from the time it was first created. If the trust is irrevocable, then the trust income is reported on a 1041, which is the trust tax return. And then the trust might make tax distributions to the beneficiary, which is listed on a K-1. A K-1 is kind of like a 1099 in the sense that it is a tax document that reports how the money is moving on paper. And the reason why it's oftentimes helpful for the trust to distribute out that income to the beneficiary on the K-1 is that chances are the beneficiary has a lower income tax bracket than the trust. And so paying for the taxes on the beneficiary's lower income tax bracket means less tax is actually due. So that's why it's helpful to connect with an experienced tax preparer, perhaps even, a CPA, in order to prepare the taxes and to understand how the money would flow. But be aware that if it's irrevocable, it's very possible that the beneficiary may ultimately report the trust income on their K-1, but the trust can still pay the beneficiary's tax responsibility. So even though it's reported on the beneficiary's 1040 tax return, the trust can still write the check if the beneficiary owes any taxes. The other common question we hear is, well, won't that impact um, my loved one, my child's eligibility for Medicaid and SSI? Because, we're going to get into it even more, after the break, but we're telling you that, Medicaid and SSI looks at someone's income. Well, if we're reporting to the IRS that the beneficiary has all this trust income, isn't that going to impact their Medicaid or SSI? Generally speaking, no, because we're talking about paper income. It doesn't mean the beneficiary actually received the cash from the trust. And that's what Medicaid and SSI are most concerned about. So we even have, some standard language that we provide to clients, or that, when our clients ask us to do it, we talk directly with the government agency to remind them, if they forget, that there's a difference between tax reporting income and actual income for eligibility for Medicaid and SSI. Now, the self-settled special needs trust, the trust that's funded with the beneficiary's own assets, this gets its own tax ID number. So remember, it's treated as its own taxable entity. Um, if it doesn't use the beneficiary's social security number, then it's going to report that income on the trust tax return, which is known as the 1041. And then again, it will use the K-1 document to pass out that income to the beneficiary. And then again, the same philosophy. The beneficiary reports it on their Form 1040. Again, typically the beneficiary has a lower tax bracket. If the trust uses the beneficiary's social security number, then the trust activity is reported on the beneficiary's Form 1040. This can sometimes be a preference of the attorney drafting the trust, or a discussion with the client, or even a discussion with the tax preparer. I personally like to get a separate EIN for the self-settled special needs trust. I actually can't really think of a situation where I've used the beneficiary social security number, but I just want to point out that there are some people, and in fact, I saw it on one of the attorney listservs that I'm a part of. I actually saw this question being asked. What do people do? I typically request a separate tax ID number for the trust, and so it looks like a separate entity from the beneficiary. I think it makes it a lot cleaner and makes it a lot easier to explain to any government agency when you're not confusing things by using the beneficiary social security number. But that's more of a personal preference, as well as just, my experience. And then Riley, I'm going to turn it back over to you to talk about care management services.
Perfect. Thank you. So, our trusts very often talk about advocacy for a disabled beneficiary. So, that advocacy clause says that either the trustee Or a professional care manager can check on that disabled beneficiary. So they become the eyes and ears of the trustee who lives at a distance or maybe doesn't have knowledge of the appropriate benefits, the appropriate healthcare decisions, placement decisions, etc. So the care manager is, again, if it's the trustee or a professional that steps in and does it, they are the person that checks in to make sure that the beneficiary is living in safe, clean, stable environments. They are seeing doctors and receiving appropriate care services. A I'm sorry, a professional care manager is a health and human services specialist who helps family access care for older relatives or those with disabilities. So, for example, professional care managers might be the parties that help family members in finding placement, whether it's placement in a nursing home or an assisted living facility for older individuals, or a group home setting or ICF for individuals with disabilities. So the care manager kind of acts as an advocate to assist the trustee in finding placement, ensuring that the proper care and benefits are being received by the beneficiary, trying to find holes in what care is being received at the time to ensure that everything continues to move smoothly for the beneficiary while encouraging as much independence for that beneficiary as possible. Care managers can also assist and monitor government benefits. So we might use our care manager to say we need to apply for certain benefits. They can assist with the application process, talking with some of these government entities. They can also be making regular visits to the beneficiary to ensure, again, safe, clean, and stable living environments. They might help to recommend appropriate disbursements from the trust. So if a family member is trustee of a disabled individual that lives in Ohio, but the trustee lives in Arizona, it is not realistic to mandate that that trustee come to Ohio once a month. Maybe every couple months that trustee can get out to Ohio to check in, but that's when the professional care manager might step in and do those regular visits and report back to the trustee to say, I went, I saw maybe that the caregiver was not doing the best job, or the living conditions that the beneficiary is currently in, we need to do some updates so they can recommend disbursements that the trustee makes to the beneficiary. Again, they can recommend placement and providers. So finding a group home, an ICF, a condo, an independent living condo, and hiring caregivers, the professional care manager can help with finding that placement or providers in an independent living situation. They can also evaluate the adequacy of the existing services and care that is being provided. And we have the care manager advocate provide annual reports to the trustee about the condition that the beneficiary is living in and the care that is being provided to them. This is our care coordinator at Hickman Lowder. Her name is Andrea Thoreau. She has been with Hickman Lowder for a little over a year now, and I work, as we all do, very closely with Andrea. And I truly, as my colleagues, I'm sure, would back me up here, don't have enough good things to say. She is a fantastic resource. Hickman Lowder was actually one of the first firm in the area to hire a care coordinator to be on staff with Hickman Lowder at all times because Hickman Lowder noticed that there was a gap in services that were being provided to beneficiaries once the primary caregivers were not around. So any person that's a trustee can hire our care coordinator here, Andrea, to check in on beneficiaries. You know, even if you're a local individual that visits the beneficiary, even just having Andrea go out once a year to put a fresh set of eyes and ears on the care situation, that's absolutely something that you can do as trustee. The trust resources, whether it's Andrea or any other professional care coordinator individual, the trust pays for the services that these professional care managers provide. So we're going to talk now about some of the reporting requirements to benefit agencies. So if a beneficiary receives SSI or Medicaid, you would need to report the following about the special needs trusts that either our office or anywhere else, any other attorney's office has created. So you should report when the trust is funded and that the person with a disability is the current beneficiary. You would also report when countable distributions are made. Those countable distributions are ones that are not used for the exempt purposes. You might also have to report the trust assets, income, and disbursements if requested by the government agency. Again, that might just be upon request or at annual redeterminations. And then when the beneficiary shows income from the trust on their tax return. For Social Security purposes, column 1 has you should be reporting a change in the beneficiary's living arrangements, a change in the beneficiary's income, a change in countable resources, and any new eligibility for other public benefits. Those should be reported within 10 days after the month the event occurred. You should also report substantial medical improvements that could result in the beneficiary no longer being disabled, a change in the beneficiary's marital status, admission or discharge from any health facility, including a hospital or nursing home, and any intended trips outside of the United States. Sometimes we have clients that receive a denial of benefits. So if Social Security or the Department of Job and Family Services that handles Medicaid notifies a beneficiary that there will be a reduction or elimination of the beneficiary's benefit that they're receiving, those should be appealed immediately and certainly within 10 days, because that 10 days won't terminate or eliminate those benefits. They will be placed on hold until and continue until there is a larger determination that will occur. So you are allowed up to 60 days to appeal a Social Security decision, but again, 10 days if you want to preserve that benefit. So it really is incredibly important to ensure that Social Security and the Department of Job and Family Services, again, that covers Medicaid, have the correct address for you and the beneficiary on file. If benefits are terminated, you should be loaning money, not just giving money to a beneficiary, because we want to avoid further penalty from giving money to a beneficiary.
Okay, I think we have now reached our halfway point in terms of the slides and the questions. Matt, let me ask you, do you have any questions from the chat?
We do. So the first one I will say is somebody had asked about if we were going to talk about stable accounts and special
Mhm.
needs trust. So I just want to say we will talk about that later, a little bit later in the presentations. And then if we don't cover what specifically they wanted to hear, then we can talk about it again. But the first one I will ask, since we're about to talk about it a little bit, is for Riley. Somebody asked, when you say SSI, does that cover SSDI as well? So if you just want to talk about a little bit of the difference between those.
Yeah, so we're going to get into that a little bit more, but SSI and SSDI are separate. I will, right after we're done here, actually start covering that.
All righty. So the next one will be for Amanda. It says, if our son, who's 33, never was declared disabled through SSI, can he qualify for a special needs trust? He has school records for a cognitive disability and receives services through OOD. He works and they want him to continue working.
Great question. So for the type of special needs trust that an attorney would draft, absolutely. There's not a requirement that someone receive public benefits to be eligible, to be a beneficiary of a special needs trust. In fact, we oftentimes use special needs trusts for someone who maybe needs public benefits in the future, but doesn't actually receive them now and has never received them in the past. So it's really a forward-thinking tool. And then if they don't need public benefits, then the trustee has a lot of flexibility on how they can administer the trust. On the other hand, the one thing I can think of where that would be an issue is if you wanted to do one of the pooled trusts, they do have a requirement that in order to join their trust, that the beneficiary has to have a disability, and it must be something that can be proven typically through eligibility for SSI or Social Security disability or childhood disability benefits, which Riley's going to talk about after the break. So that would be one exception. But otherwise, no, there's no requirement to be on public benefits in order to have a special needs trust.
All righty. Next one, I'll stick with you for the next couple, Amanda. The first one is, can the sole benefit trust be created for the benefit of a child that currently doesn't have a disability?
Oh, yeah. More good questions. No. Under Ohio law, the one of the factors is that the individual is a person with a disability. And so it is a requirement. I will say there's some other planning techniques that can be used if the child does not have a disability, but there are pros and cons to those other techniques. So they're not identical to a sole benefit trust. So the answer is no. To use a sole benefit trust, the beneficiary does have to be a person with a disability.
Okay. And then next one, can the beneficiary serve as the trustee of the special needs trust upon the passing of the current trustee?
Unfortunately, no. If the serves as their own trustee, they have too much control, and that's the same as giving the beneficiary cash. So it would cause them to be ineligible for any of the means tested benefits like Medicaid or SSI. So there's also some tax ramifications of having the beneficiary serve as their own trustee. At that point, you would just give them the cash.
All right, I'm going to jump over to Riley, because since you talked a little bit about hiring professionals to help the trustee.
Mhm.
So there was a question, what type of assistance would be considered applicable for managing a special needs trust? And to go with that, can trustees use funds from the trust to pay for professionals to help advise them, such as healthcare or accounting professionals?
So I'll answer the second one first. Yes, the trustee can absolutely use funds in the trust to hire and pay for those additional professionals. That is you doing your duty to ensure that you are doing everything to the best of your ability to protect that beneficiary. And then assistance applicable for managing a special needs trust. The individual maybe would need a caregiver, so you could hire a caregiver, you could work with again, professional care coordinator to maybe find placement instead, or hire private caregivers that could come into the home, um, tax preparation. Um, I think there's a lot of different things that really could apply, and it's not just to the special needs trusts. It's really to all the kinds of trusts, depending on your skill set as well that you have as trustee.
All righty, back to Amanda. Someone asked, if my trust is revocable, will my trustees be able to change the trust if the change is in the best interest of my children? One example might be an administrative change if laws change versus a change based upon the trustee's personal wishes.
Okay, sure. So if the trust is revocable, then the person who created the trust would also have the authority to make the change. So we wouldn't even have to look to the trustee to make the change. The person who created the trust would be able to make the any kind of changes, especially if there are changes in policy or government benefit, eligibility. If the trust has become irrevocable because the person who established the trust has now passed, or it was always irrevocable, it would partly depend on the trust agreement, but generally speaking, the trust can be changed, um, or we can do a couple of other things, including Ohio has something called decanting, where we literally create a new trust and can pour the first trust into the second trust. And when we do that, the person is able to stay eligible for their benefits. So sometimes it's a very simple mechanism. Sometimes it takes a couple steps. But yes, if there are changes in the law, especially related to government benefit eligibility, future trustees typically have a mechanism to do that.
All righty. Amanda, I'll also ask you, what happens if my Medicaid payback trust funds are all used up during the beneficiary's lifetime? Can the trust still, or does Medicaid still look for a payback?
So Medicaid's claim doesn't expire, but if they don't have anything to attach to, then they don't have anything to attach to, and they won't go and ask the trustee to personally be responsible or ask anyone else to pay for it unless, someone had done something improper and, had taken money for themselves. So the claim doesn't go away, but they just don't have anything to attach.
All right. And you mentioned a little bit about taking beneficiaries on vacation at the beginning. So this one says, can my son's special needs trust be used to cover his costs to travel on vacation with us, such as airfare, accommodation, restaurant meals? If so, what restrictions are there? Context, he lives with us, pays a modest room and board, gets SSDI, Medicare, and Medicaid, and is 30 years old today. Tell him we said happy birthday.
Yes, happy birthday.
As we age, we want to travel, but he can't be left at home while we travel.
Yes. Typically, the beneficiary's travel costs. And I'm going to give you a very annoying lawyer answer, which is reasonable travel costs. Sometimes that means like an $8,000 cruise because that's the going rate for the cruise, right? That doesn't mean that someone has to pick the cheapest seat on the airplane. If that means first class airplane ticket and that's what, everyone else in the party is doing, then that means first class airline ticket. So there's not a dollar amount, there's not a cap on that. It just needs to be reasonable. And in fact, if the beneficiary needs help traveling, the beneficiary could not travel independently. The trust can even pay for one other person's travel plans. That can even be a family member. It doesn't have to be a stranger or, a paid third party aid. So we oftentimes see if it's, let's say, mom, dad, and adult child is unable to stay at home by themselves, but they also cannot travel independently because of intellectual disabilities or physical disabilities. The trust can pay for that adult child's travel expenses as well as one parent's travel expenses. And so there's a lot of opportunity to provide for meaningful life experiences through the trust. And Matt, if you don't mind, I think we'll maybe pause there because I know Riley really wants to get into benefit eligibility and there's a lot of stuff to get in there. So why don't we pause and then we can circle back at the end and pick up any questions we didn't address and any new questions?
Sounds
All
good.
right, so please feel free to continue typing your questions in the chat. And if you want to retype your question, if we didn't get to it, we'll try to make sure. And I'm sure we don't mind going a little bit over noon to make sure that the questions get answered if you all don't have anywhere else that you need to head to at noon. But I want to make sure we get through all of our slides as well. So Riley, I'm going to hopefully successfully go back to slide sharing. Um, Okay, can I get confirmation that you can see the question slide?
Yes.
Okay, excellent. And then I'm going to advance here, and then I'm going to turn it over to you, Riley.
Okay, so now we are getting into our definition of disability from the Social Security Administration. So, for a person to be considered disabled, we need to have three prongs, I will call them, met. You need to have a physical or mental impairment that lasts 12 months or longer or results in death, and that impairment prevents a person from engaging in substantial gainful activity. So, substantial gainful activity for an individual in 2026 is $1,690 a month. So if that individual cannot make that amount of money and meets the other two prongs, they will be considered disabled according to Social Security, and they can become eligible to receive benefits. So here we are starting to address one of our questions from earlier, the difference between SSDI and SSDI and SSI. So SSDI is Social Security Disability Income. It applies to individuals that are disabled according to Social Security's guidelines. It is a non-means tested benefit. So you can have $1 million in the bank and still be eligible for SSDI after a 24-month period. If you are still qualifying for SSDI, you will also become eligible for Medicare. SSDI is tied to work history. So, as a general rule of thumb, we say that the individual is paying or was paying into Social Security for 10 years from work history, but there are some exceptions. That exception is the SSDI Childhood Disability Benefit. So this is CDB. So a child that was disabled prior to the age of 22 can earn SSDI credit off of their parents' earning history once the parent retires, becomes disabled, or passes away. Again, this is a non-means tested benefit, but SGA, so that substantial gainful activity, is still relevant. The, sorry, I'm going to have you go back for just a second. The disabled child, will qualify to receive 50% of what the parent receives from Social Security once they retire or become disabled. And then once that parent passes away, the child is eligible to receive 75% of what the parent received from their Social Security income during their lifetime. And the great thing, I've had a lot of clients ask me, is this going to affect my Social Security benefit that I receive every month? But it does not affect your Social Security benefit. So if your child that's disabled receives 50% of yours, you're not getting reduced by 50% because they're receiving that. I'm good now, Amanda. Thank you. And then Amanda, yes, this is yours.
Okay, so SSI and Medicaid. These are frequently spoken, about in the same sentence. These are our means tested benefits. And, why do we call it means tested? Because there is a resource test, or there is an income test, or there is both. So to be eligible for SSI or Medicaid, you have to be disabled according to Social Security's definition, which Riley told us is a physical or mental impairment that lasts 12 months or longer or will result in death. And you must apply for the program. They generally don't knock at your door and say, hello, we have identified you as someone who might be eligible for SSI or Medicaid. So you have to proactively apply for the program, and you have to meet the financial eligibility, which is for Medicaid and SSI, both a resource and an income test. So income and resources, I think this is something that many clients oftentimes struggle with understanding the difference. So income is what you get during the month. It might be monthly, it might be quarterly, it might even be once a year. It might even be just once, but it is what comes in during the month. So that is income. Very common income would be earned wages, interest from a bank account. Technically, the inheritance from grandma, that is unearned income that month. You just get it once, right? You just get one check, but that is income. If you still hold on to that income the next month, then it's a resource. So income can become a resource if the income is not spent in the month that you receive it. A resource can also be something that did not start as income. So if you own multiple vehicles, your multiple vehicles could be a resource. It didn't start necessarily as income, but the vehicle can be a resource, or that coin collection could potentially be a resource. So it's not just the money that comes in that becomes a resource. Tangible property can be a resource as well. Any change in income has a 10-day reporting requirement. So if you're already receiving Medicaid or SSI, you do have a responsibility to notify those government agencies of any changes in income. And again, some examples of income might be wages. You don't have to notify Medicaid or Social Security every month that you got paid on Friday. That's not what they're talking about. It would be a change in your typical income, wages, inheritance, bank account interest. And then, um, this is we're getting into the weeds a little bit, but it might be helpful to know that for income, um, $20 of unearned income, meaning income that doesn't come from wages, is disregarded. So if you got paid $60, Medicaid and SSI would only count $40. Medicaid and SSI disregards $65 plus one half of earned income. And I'm sorry, I just gave a very bad example. I said that in reverse. They disregard $20 of unearned income. So that's not wages. That would be if, your mom gave you $40, that's unearned income. And so they disregard $20 of that. So $20 would be counted technically as unearned income. They disregard $65 plus one half of earned income. So earned income is looked at more favorably. There are impairment related work expenses or IRWEs. These are expenses that someone has in order to engage in employed work. We have clients who, for example, might have work expenses. Like, for example, an aide comes to the home to help them get out of bed in order to get dressed to go to work. That might be considered an IRWE. And those types of IRWEs can be deducted from income, which can help someone who is actively employed be eligible for certain programs. This, I think, was perhaps a little bit more relevant before we had Medicaid buy-in for workers with disabilities, which Riley's going to touch on. Um, but it is something to still be aware of, especially with as it relates to Social Security. And then deeming. While a child is under the age of 18, their parents' income and resources deem to that minor child. But when the child turns 18, even if they're still living in the household of the parent, that deeming typically is no longer applies. And resources. As we said, resources are owned by the individual. They're available to the individual and they're not exempt. So again, using the example of one vehicle. Well, a vehicle is technically a resource, but under Ohio law, one vehicle is exempt. So we start off with saying it's a resource, but then we get to say it's an exempt resource. So we get to take it out of the countable resource pile. And that is an analysis, that is done when we're trying to determine if someone is going to be eligible for benefits or if someone is already on benefits and they come to our office and they're concerned about an inheritance or other reason why they might be receiving uh, resources or an asset, that's the type of analysis that would be done. And again, there's deeming of the parents' assets when there's a minor child, and also there can potentially be deeming between spouses. That can occur as well. But normally, when we're talking about deeming, we're thinking about the fact that a minor child may not be eligible for benefits because of their parents' income, or in this case, in parents' resources. Exempt resources, as I've mentioned, we have a vehicle on here, household goods, clothing, furniture, those are not things that we necessarily have to disclose to Medicaid or Social Security when we're applying for SSI. The primary residence that the individual lives in, not a resource. An irrevocable funeral contract, burial plots, whole life insurance with total face value of under 1,500. The back payment from Social Security. So if someone applies for Social Security disability and it turns out that their application took a while for Social Security to review, and they end up getting a lump sum, well, it actually can be exempt if they're on Social Security disability, then we're really only concerned about Medicaid eligibility, and it can be exempt for 6 months. If we're talking about an SSI lump sum, then it's exempt for 9 months. But after that 6 or 9 month period, it becomes an available resource if it's not spent down or transferred to a trust. If you remember from one of my slides at the beginning of the presentation, and I said, why would someone need a self-settled special needs trust or Medicaid payback trust? A lump sum from Social Security was one of those reasons. A properly drafted special needs trust or pooled trust is an exempt resource. The third party discretionary trust, exempt resource, and an able or stable account, which we're going to talk about at the end today. Those are all exempt resources. Okay, I believe, Riley, it is now your turn.
Yeah. So we're going to step into the world of Medicaid, and I am going to get us through the rest of the presentation. Okay. So we're going to start with Medicaid, aged, blind, and disabled, ABD, as you might hear us refer to when we meet with you in the office, ABD Medicaid. So ABD Medicaid provides health insurance and medical assistance. So for hospitalization, health aids, medically necessary in-home care, which typically happens through a waiver, equipment, prescriptions. Medicaid is means tested. So you can have of resources $2,000 or less for an unmarried individual and an income of $994 a month, again, for an unmarried individual. Once you qualify for SSI, you automatically qualify for ABD Medicaid as well. I will note too, Medicaid is the insurer of last resort. So if you have dual eligibility, meaning you have Medicare and Medicaid, whatever Medicare does not cover is covered then by Medicaid. I also here will just touch on Magi Medicaid because I know that that affects clients sometimes. So Magi is modified adjusted gross income for that type of Medicaid. The individual does not need to be disabled. Medicaid just looks at the income that the individual receives on a monthly basis. Now I'm going to talk about some of the waiver programs. The HCBS waivers provide, again, like I was saying, home healthcare services for those that need those either in their private home or, in an independent living facility that they're at. This is what keeps that individual out of a nursing home, a hospital, or another long-term care facility. There are many different programs, and these cover the services and support that are not paid as part of the original Medicaid plans for healthcare coverage. So there are different kinds of waivers that we talk about here. So the Ohio Department of Developmental Disabilities waivers assist individuals with developmental or intellectual disabilities. And then there are other Ohio Department of Medicaid waivers like the home care waiver, the assisted living waiver, Passport, MyCare Ohio, and Ohio Rise that are for additional disabilities or other health conditions. There is also Medicaid Specialized Recovery Services, SRS. So this is targeted toward two groups of individuals, those with severe and persistent mental illness or severe chronic conditions. To qualify, the individual's income must be below $2,982 a month. They must be 21 years of age or older, and this provides various resources. Um, there is no asset limit or test to qualify for this. And then our last portion of Medicaid programs here is the Medicaid buy-in for workers with disabilities. So individuals between the ages of 16 and 64 that meet Social Security's definition of disabled and earn no more than 250% of the federal poverty level, which is about $3,260 a month in 2026, that are employed in part-time work, meet citizenship requirements, and have resources of less than $15,668 qualify for Medicaid buy-in for workers with disabilities. So I just want to take everyone back to remembering to qualify for most of these Medicaid programs. You have that limit of $2,000 that you can have. Those individuals that can work and have income qualify for Medicaid buy-in for workers with disabilities, and they are allowed to have that limit of $15,668 of resources. But they may pay a premium based on the income that they receive every month. But this is what we have for those that are out in the workforce and helping with their health insurance care. I'm going to take us back to SSI for a minute here. So that's the supplemental security income. So this is the federal income program for persons with a disability that do not have Social Security coverage. As we touched on before, it is intended to pay for food and shelter expenses. It's administered by the Social Security Administration. You again have to apply for these benefits. Like Amanda was saying, Social Security isn't going to come knock on your door and say, I think there's a disabled individual that lives here that can qualify for benefits. So you can complete and apply for SSI benefits online at ssa.gov or and you will apply in person. So again, this is means tested. So your countable resources have to be less than $2,000. The 2026 benefit for SSI monthly for an unmarried individual is $994. The representative payee is the party that receives SSI or SSDI for the benefit of another individual. And I will just note, because when you have an individual with that's receiving SSI, sometimes we apply for guardianship and other things with the probate court. The representative payee is completely separate from anything we do in the probate court as well. So, like I was saying, SSI is meant to cover food and shelter expenses, which are called in-kind support and maintenance, ISM. So, if there is direct payment of shelter expenses by a third party, so maybe a parent is providing those expenses by allowing their disabled child to live in their home rent-free, or a trust is paying for the in-kind and support in-kind support and maintenance expenses, that is treated as countable income to the recipient. So Social Security can reduce the benefit of $994 by 1/3 because a third party is providing that benefit for an individual. I will note that in September of 2024, there were new rules enacted. So, again, as long as the individual pays, and we're using this year's numbers, so again, the $994, if we cut that by 1/3 and add $20, that disabled individual should be paying at least $351.33 to receive the full $994 a month benefit. And food is no longer included in ISM, so in-kind support and maintenance. Ohio Medicaid does continue to include food in the ISM. However, Medicaid will exclude ISM if the individual is receiving SSI and the Social Security Administration is not imposing a penalty. So now I'm going to get into some of the transition timelines that we deal with our clients. So the typical transition to 18. Often families begin working with Hickman Lowder when their children are very young. So there are clients that even I, as a newer attorney, have watched transition to 18, and some of our more experienced attorneys, Janet Lowder, for example, I'm sure so many of you are clients of hers. She has watched your children grow up their entire lives. So we watch as these individuals transition to 18, and we're here to help with that. So once that disabled individual turns 18, like Amanda was saying, parents' income and resources no longer deemed to the child. So that's the big time that we advise clients to start applying for these government benefits like Social Security and Medicaid. If they will meet the disability test and income and resource requirements, you should start applying at 18 for those benefits. Once a child turns 18, parents are no longer the legal decision makers for their children. So that's a good time in preparation for this transition to meet with us to talk about guardianship or powers of attorney. So I'll just touch briefly on that here as well. So guardianship, we apply for guardianship when an individual cannot basically understand and sign a power of attorney. So if that individual is incompetent, cannot understand and sign a power of attorney, we will go to the probate court and apply for guardianship. I've been finding that every county has their own requirements about when you can apply, whether it's a little bit in advance or you cannot file even until the individual turns 18. But we are happy as families get to that point to guide you on those decisions. The alternative to guardianship that we have right now in Ohio is a power of attorney. So your child can talk with us, let us know who they would want to help them make financial decisions, make healthcare decisions, and we will go through this whole process with your family. At this time, we are also starting to draft these room and board agreements. Because again, if your disabled child is turning 18, they are living with you, you are paying for all their expenses. Social Security can cut that $994 a month payment of SSI by 1/3. So what we do is we create the room and board agreement. Those we find have been Social Security isn't required to honor those, but we have had really good results with it in ensuring that your disabled child will receive the full benefit. We also will help with guidance on the transition for adulthood. Typically, when individuals turn 18, mom and dad are still working. So, as parents near retirement, that's another great time to meet with your attorneys, our office, and start talking through some of these additional benefits that your child might be receiving. So, like I was talking about earlier, we were talking about SSDI and the CBD benefit. This was formerly known as a DAC benefit for a disabled adult child. Again, like I touched on, the child that has the disability ruling by Social Security is eligible to receive half of the parent's benefit. So, whichever parent paid more into Social Security, they can receive half of that benefit when the parent retires. Once the parent dies, your disabled child could be eligible and would be eligible to receive 3/4 of the parent's benefit. Again, after that 24-month waiting period, your child will also qualify for Medicare eligibility. And now, like Matt was telling you guys, we are going to start talking about ABLE accounts. So an ABLE account in Ohio is called Stable. It is a savings account for individuals with disabilities that does not affect eligibility for means tested benefits like SSI and Medicaid. In 2026, we had an update. So now any individual that was disabled before the age of 46 is eligible to open an account. Prior to 2026, you had to be 26. So we've increased our age, and this has opened doors for a lot more individuals to create an account and have some extra funds that they can use during their lifetime. So again, you have to be a disabled individual, whether that is the ruling from Social Security or self-certification. The person can be a beneficiary of only one ABLE account. So you can't open multiple ABLE accounts. You can just have one. And that individual may not be required to be a resident of the state, depending on the policies of the ABLE account. So an ABLE account or SABLE in Ohio, again, can be established by and opened by the individuals listed here, and it has an order of priority. So the beneficiary or owner of the account can be the person to establish and open. If that individual is maybe not competent under guardianship and cannot establish the account on their own, the beneficiary's authorized legal representative can establish the account. So that's someone chosen by the beneficiary, a power of attorney, a conservator or legal guardian, a parent, sibling, or grandparent, and finally, a representative payee. Any person can contribute to an ABLE account. So person is an individual, a trust, an estate, a partnership, association, company, or corporation. The annual contribution limit for 2026 is $20,000. So sometimes when we have individuals that receive maybe an inheritance or a settlement of about or around $20,000, around there or less, instead of establishing a special needs trust, we might suggest that that individual spend down part of the money and then put the remaining amount, again up to $20,000, into the stable account. Or again, if it's at or below that $20,000, you can put that entire amount into stable instead of creating a special needs trust. The impact of the stable account on SSI and Medicaid, like I said, it won't affect SSI and Medicaid. It's not counted. But once we get to a certain threshold of money, then benefits can be affected. So for SSI, if the account exceeds $100,000, the individual's SSI eligibility will be suspended. However, eligibility for other programs like Medicaid and SNAP will continue even if you are over that $100,000. And then on September 30th, 2025, stable accounts were no longer subject to Medicaid reimbursement at the beneficiary's death unless subject to federal law. So there are some options that we can discuss as well regarding that repayment to Medicaid upon the beneficiary's death. The stable account has some great benefits that might not and are not allowed by some of our other accounts. So for stable accounts, you are permitted to pay qualified disability expenses. Qualified disability expenses are those that relate to the beneficiary's disability, are for the benefit of the beneficiary, and are used for maintaining or improving the health, independence, or quality of life of that beneficiary. So some examples that we see individuals use stable accounts for include education expenses, housing and living expenses, which, if you recall from our special needs trust, as our general rule to preserve SSI benefits, we say don't pay those expenses. Those expenses can be paid from the stable account without affecting SSI, unlike those trusts. Transportation needs, employment, expenses for the stable accounts oversight and monitoring, legal fees can be paid, as well as funeral and burial expenses. I find that the stable website is incredibly helpful for clients and list out even more examples. Unfortunately, my slide was not big enough to include them all. So you can absolutely look at the stable website as well to get more information on these accounts. And then I will turn this back over to Amanda as we get ready to wrap up.
Okay, so we would just like to use this as an opportunity to remind those of you out there who already have a trust or an estate plan in general. And when I say estate plan, that can include wills, financial powers of attorney, healthcare powers of attorney, the way you title your home, beneficiary designations. I mean, at Hickman Lowder, we look at it from a very holistic approach. What is everything that could happen during your lifetime as well as at your passing? And we recommend that you review that periodically. You want to make sure that your assets are titled correctly and that the beneficiary designations are the way that you want them today, maybe not necessarily how you set them up when you were at the bank 15, 20 years ago. Reevaluate, are the people that you've named as trustee and advisor, advocate and guardian still the people that you would want to serve in those roles? Have there been any changes in the beneficiary situation that might want might cause you to revise the documents. Have there been changes in your economic situation? Or perhaps you did planning when you had, three children and all three of them were minors, and now those children are adults, and maybe their ability to be gainfully employed looks a lot different. And you want to maybe not treat them equally. Maybe you want to change the allocation. There's a lot of things that could be happening. If there have been personal changes like birth, death, divorce, marriage, adoption, you've moved, maybe you did a transfer on death for your house, but you moved and you sold that house and you've moved. Did you do a transfer on death for the home that you currently live in? And if there have been any changes in the law, you're always welcome to reach out to us and ask us to review the documents that we've prepared to see if there have been any changes. Just to give you peace of mind, there have not been significant policy or law changes in the past 10 years where we would be advising, large numbers of clients to make changes. But we do recommend that you pull out your documents and check those beneficiary designations as frequently as you want to, but as a minimum, every 3 to 6 years. And tax time is a good time to do it because you're getting reminded of some of those things. You're getting your insurance premium notices, or you're getting those 1099s, and you're like, oh yeah, I need to check my IRA beneficiaries. I need to check this. I need to check that. So, with that, it is 12:02. So we have officially reached the conclusion of our time here today. So if you need to exit, please feel free to do so. But otherwise, I'm going to ask Matt if he would read off some of the questions in the chat that we haven't already addressed.
Yep, there's a few left, so I'll start with Riley, since you talked about reporting requirements with SSI and Medicaid at the beginning. Someone just asked, what is the process to report to SSI and Medicaid?
Okay, so you have a couple options. You can call your local office to report. You can make an appointment, collect all the documents, and submit them online. The important part, obviously, is just that you do make those reports in a timely manner so as to not affect any of the benefits that your child or other disabled beneficiary is receiving.
And Riley, would you agree that having proof of the reporting is helpful as well?
Absolutely. It is incredibly important to make sure that you keep a paper trail just in case.
Alrighty, so Riley, I'll stick with you. There was one through a hearing. My beneficiary was denied SSDI. Does this negate the self-settled Medicaid payback trust, special needs trust?
So we're saying that
You want me to
are they
reread it?
receiving, do they have a disability diagnosis and they were just denied SSDI benefits?
I am not sure.
Okay, so if that's the case, if the individual
She
is
put in the chat, no disability diagnosis in writing.
okay, so if we don't have a disability diagnosis, one of our prongs for establishing these trusts is that the individual be disabled. So,
Maybe Riley, I can step in here.
sorry, I'm a little confused.
No, that's okay. And I kind of touched upon this.
Okay,
So the if someone has not been found to be disabled, they can still have a Medicaid payback trust. It's just that the trust can be administered in a little bit more flexible way because we don't have government benefit eligibility issues to be concerned with. But please don't feel that the trust, is, as we say in the estate planning world, going to blow up. We don't have to undo what has been done. It just provides a lot more flexibility. And if the beneficiary, reapplies or appeals, then the trust could then kind of do what it was intended to do, which is protect that eligibility. But no, getting denied Social Security disability, either because the person was found to not meet the medical criteria or because the person didn't meet other criteria, does not mean that the trust is no longer effective or useful. The beneficiary does not have to be a person with a disability diagnosis at the time that the trust is created, with the exception of the pooled Medicaid payback trust, because that's that organization's requirement that they want to see proof of a disability. And if that doesn't fully answer the question, feel free to reach out to me and I can help address that a little bit further.
Yeah, thank you. So Amanda, the next one will be for you. This one says, what happens if a beneficiary outlives assets in a special needs trust? How will expenses be funded?
Yeah, that is the really challenging question, isn't it? Definitely making sure that we're maximizing government benefit eligibility, because that might be where a lot of the income is coming from. But that really goes to trying to figure out how much to fund the trust with, and looking at things perhaps like life insurance or other ways to help fund the trust when the caregiving uh, when the people providing the caregiving, like the parents or the siblings, might not be there. But ultimately, if the trust is exhausted, the beneficiary is going to be limited to whatever income they have, whether that's Social Security or earned income.
Okay. And then another one for you, Amanda. It says, if my daughter has a child, can the trust pay a nanny slash household help? I'm assuming the daughter is the beneficiary of the special needs trust. And I believe it was Mrs. Herbst that just said another thing in the chat that asked that. And yeah, and she also says, if my daughter gets married, does the trust still exist as a special needs trust?
Okay, so I'll address the marriage first. Yeah, marriage does not terminate the special needs trust. Marriage might terminate some benefits depending on what benefits uh, your daughter receives. As a married person, her spouse's income and resources may deem to her. And then if she's receiving CDB benefits, the childhood disability benefits, getting married to someone who is not also a CDB beneficiary is going to permanently sever the CDB benefit, meaning you can't reapply for the CDB, even if they get divorced later. Um, so keep in mind that while the marriage will allow the person to still remain a beneficiary of the special needs trust, it might cause them to be ineligible for some of the benefits that they're currently on or benefits that they want to apply for later. And then regarding, payment for the beneficiaries' dependents, like the beneficiaries' children, depends on the trust agreement. Generally, um, well, it depends on the trust agreement. And it also depends on the trustee. If it's a bank trustee, they might not be willing to make a distribution, as we say, or, use trust money for someone who is not a named beneficiary, meaning the child of a beneficiary. However, it might be possible as long as it's not a self-settled Medicaid payback trust. A Medicaid payback trust it must only be used for one beneficiary, and it cannot be used even for that beneficiary's children. So look to the trust agreement, see if it would be allowed, see if there's anything that would prevent it from being allowed, and then talk with the trustee, and then see if it's a good idea, even if it is allowed. But it is possible. It depends on some specifics that we don't have in front of us today.
All righty. Riley, I'll jump back to you for a group of questions about stable accounts.
Gotcha.
So the first one, they want some pros and cons of stable accounts versus special needs trusts, but they also would like to know what happens to the funds in a stable account upon the death of the beneficiary.
Okay. So upon the death of the beneficiary, some outstanding qualified disability expenses could be paid. So, for example, one of those disability expenses was funeral arrangements. So you could use the funds in the stable account to pay for some of those. It's possible that the funds could be transferred to a successor beneficiary that is another disabled individual that again qualifies for a stable account. But the other option is that those funds would transfer to the estate of the disabled individual. And from there, while we do say Medicaid doesn't get repaid directly out of the stable account, Medicaid can state a claim against the estate of the disabled individual for up to the amount that they provided, they being Medicaid provided during that beneficiary's lifetime. So again, while it looks good on paper, Medicaid does still have a way to get that money possibly. Okay. And then some of the pros and cons with the stable account versus a special needs trust. The stable account maybe gives a little bit more flexibility to individuals. They don't need to go through a trustee to get those funds. Those funds can be used for, again, certain things that we don't always recommend that a special needs trust pay for, like room and board expenses, shelter expenses, things like that. But one of the drawbacks is you can only put $20,000 into that account for 2026. So if your disabled beneficiary is receiving funds that are maybe 60,000 or $100,000, absolutely they can put part of those funds into the stable account, but they will still lose benefits if the rest of those funds aren't put into another exempt place, whether that's a self-settled first party special needs trust or a pooled trust, whatever options are available there.
And this one kind of relates to that as well. It just says, can able accounts be funded annually from trust funds?
Generally speaking, they absolutely can. You just have to recall that if the trust is under court supervision, you would have to get court approval before that funding occurs.
Good. And then two more on the stable accounts. First one is, if an inheritance is small enough, under the $20,000, can it be put into a stable account?
Absolutely. The again, the limit for 2026 is $20,000. So even if it's a little bit more than that, let's say it's $25,000 and the beneficiary needs a new car, a new couch, you can spend down that money and then whatever's left over up to $20,000 can be placed into stable.
All right, and then one more on stable accounts. If a
Okay.
beneficiary attains employment being paid more than the substantial gainful activity, can she keep her stable account?
Yeah, absolutely. The requirements are that, you're disabled before the age of 26. Your limit, again, $20,000. So did I say 26?
That's okay.
46.
Riley, we're so used to it. We're so used to saying 26.
Yes, 46, 46. Yeah, the SGA won't affect your stable account. You don't have to liquidate it or anything like that. You're all set to continue to have that.
All right, then I'll jump back over to Amanda. This one asks, can the trust purchase life insurance on the beneficiary, which would provide funds for their child who's 4 years old in the event of their premature death?
Possibly. It would depend on the trust agreement. And then it would depend on who gets the assets at the beneficiary's passing. Does the trust agreement name like the beneficiary's child, or in general terms, does it just say it would go to the beneficiary's children if the beneficiary passed away? But generally speaking, it is possible for a trust to pay for life insurance premiums. We would just have to see if the trust agreement limits that in any way, and if there's any other reason why that should not be done. But that is a possibility. On the flip side, we also see that where the trust maybe pays life insurance premiums on the caregivers. Maybe that's parents or grandparents or siblings. And so if they pass away, it's used for the beneficiary. And then perhaps the beneficiary's children are named if the beneficiary passes away. So then if that money is still available, it's used for the next generation too. So it is possible. I would just say we would need to make sure that the trust agreement doesn't have any limiting language.
All right. The next one, both of you may be able to chime in if you have thoughts on it, but it just says, what amount of food and rent can be paid by a parent if the beneficiary is on CDB SSDI benefits and receives Medicaid assistance with a medication that costs more than $20,000 a month under a mental health program?
Okay, so I am when I see that question, I'm not focusing so much on the CBD and the Medicare because those are not means tested. If the individual was only receiving the CBD Social Security benefit and the Medicare, I would say you could pay all of the shelter costs and it would not impact their benefit. The part of that question that I'm focusing on is the comment about receiving Medicaid. So it would depend which Medicaid program it is. But I am going to assume that it is an ABD, age blind and disabled Medicaid, perhaps an SRS Medicaid. I'm going to assume it's not Magi Medicaid, which is for anyone who is lower income, but it doesn't have a disability component. So with those assumptions, Medicaid does not have an exemption really for shelter. Um, I would encourage that the Social Security disability be used for shelter expenses. And if assistance was needed, I would use it more on the prescription benefit because someone can help pay for prescriptions without impacting the beneficiary's Medicaid eligibility. But if someone helps pay for their rent, electric, water, sewer, gas, the 10 things that are identified as shelter expenses in Ohio, that person could have their Medicaid impacted because that's going to be considered unearned income. Another thing I want to point out is that if you want to make money available for shelter expenses, you could use a stable account. So parent, let's use the example of parent wanting to pay for shelter expenses. Parent could contribute to the stable account up to 20,000 a year, based on 2026 dollars. And then the beneficiary of the stable account could use the stable account for shelter expenses. And as long as they use it in the same month that they make the withdrawal from the stable account, there is no in-kind support and maintenance. There's no Medicaid penalty. So that might be a way to work with the rules without impacting the person's Medicaid eligibility. Riley, did you want to clarify or add anything to that?
No, that was very good. I
Oh,
think you covered all of it.
well, thank you,
Yeah,
Riley. I appreciate that.
All right, so one more for Amanda. Um, this one's about Social Security. Would the child drawing on a retiree's benefits once the retiree starts drawing impact the spouse who wants to draw on those also? Is there a cap if all three are drawing on the same Social Security at the same time?
Yes. So, oh, you know what? I forgot to mention, thank you. Today is Pi Day 3.14. And that kind of ties into we have the Social Security pie where, the pie can't get any bigger. It's based on the wage earners' contributions into Social Security. And the question is, how are we cutting the slices of the pie? And Riley did a great job at explaining like how we divide things between the wage earner and their adult child who might be collecting on the wage earner's Social Security history. However, when we add a spouse to that, those slices start looking a little different. So I can't give you a firm like, well, the spouse gets this percentage and the child gets this percentage because it's actually a little fuzzier than that. But to answer your question, you're on the right track, which is thinking, yes, it actually does impact. And it's rare, but I have actually seen situations that when the wage earner spouse passes away, the um the adult child's benefit, the amount they get up goes up because remember it goes to 75% and the surviving spouse actually gets less. So it's rare, but actually can happen. It's the way that they're dividing the pie. I think there is a calculator. I don't know the URL off the top of my head, but I think there is a way to calculate that um, uh, to get like a more clear answer for your specific family. Great question, though.
Alrighty. I believe the next one, the gentleman may have left, but it may be helpful for other people. He just asked, do you have a tax accountant that may be recommended? If there's anybody else that may be looking for one.
Great question. I would suggest that maybe people contact us directly. I'm not sure that I feel comfortable making a referral on something that might be out, in the public. So if you want to just, reach out to us, I'd be happy to provide a couple of names. Um, if I would say that people that have a firm understanding of all of the nuances of special needs trusts are rare. And so it is helpful to develop a relationship with a tax preparer or CPA and cultivate that relationship. And if you find someone who does a good job and is responsive and, does things, in a way that you understand, I think it's worth keeping that relationship. It's not a dime a dozen. It's not like you can just go into any place and have someone prepare a 1041 for a trust like this. So definitely cultivate that relationship. But if you'd like to give our office a call, I can let our secretaries know that a call like that might be coming in, and we can provide a couple of names. I would caution you though, I don't know that anyone will be available for the 2025 tax year because here we are already on March
Mhm.
14th. I think that maybe you'd want to maybe do your own due diligence for 2025 tax year. Might be a little late to start talking to someone new.
Alrighty. There's one last one. It's just gentleman asked what the charge would be for an initial consultation with one of us,
Sure.
the
Um,
one-on-one Zoom.
sure. I'm so sorry. I don't know that I feel comfortable sharing that on Zoom. I know if I was you, I'd be like, oh, she just doesn't want to say. But there's actually antitrust rules with attorneys, and we're not allowed to say certain things. But if you would like to give our office a call, they will be more than happy to just tell you, what the consultation fee is. And we charge a flat. I can tell you, we charge a flat consultation fee. So it. Um, we can go over any questions that you might have during that consultation, and we offer it by Zoom, in person or over the phone.
Alrighty, that's all.
Well, for those of you who are still with us, as I mentioned previously, attendees are going to receive an email with a link to the recording of today's webinar along with the slides. We're also going to include a few other helpful links like the Special Needs Alliance's trustee handbook. So that's a national handbook. So it's not specific to Ohio, but I think it's really helpful. Um, Riley's next blog post is going to discuss a couple different types of trusts. So feel free to visit our website, our resources page up at the top. Her article will be there, probably in a couple weeks. And give us about 7 to 10 days to get that email out. And if you have any questions, please feel free to give our office a call. But thank you for giving up your Saturday morning. I know it is challenging with childcare or caring for adults with disabilities. And there's a lot of pull on your time. If you have any feedback for us, feel free to put it in the chat. If there's something we can do differently, or if there's another topic you'd like us to talk on, we do this twice a year. And you can watch them on YouTube as well. But we'd be more than happy to talk about other topics if that's of interest to the group. But we really appreciate you entrusting us with this information. So, on behalf of Riley and Matthew, we hope you have a wonderful Saturday, no matter where you are. The sun is shining here, so go soak it up. And thank you, everyone. Have a great day.